So I want to take you down a rabbit hole that was so interesting to me. I just got locked into it and spent 6 hours nonstop researching it. And it's probably going to lead to me writing a research article about this particular arbitration troll. I'm not going to show Dan's email, but I'll read it to you. He says, not worth a video itself, but would likely be worth your effort to check Pacer for Sitcom Arbitration Association. It looks like something that could become the wacko go-to arbitration service and therefore provide laughs until the circuit courts decide to start doing unpublished two-pagers. SAA's business model seems to be you pay them a sum of money, they hold an arbitration hearing without telling anyone about it, you win, and the ruling gives you a good deal of money. You send a notice of the award to the company, which briefly confuses everyone on their side. They say, well, no, and then you go to a federal court to enforce the order. And so he sent me a link to a Court of Appeals decision. And this is a not precedential decision, the case of Marlon Pena versus TD Auto Finance. And it goes like this. It's very short. Marlon Pena, proceeding pro se, appeals orders of the U.S. District Court for the District of New Jersey denying his petition to confirm an arbitration award. Pena filed a petition with the District Court to confirm an arbitration award. According to Pena, Sitcom Arbitration Association determined that TD Auto Finance was liable for breach of contract and awarded him $116,313. TD Auto Finance moved to dismiss the petition pursuant to Federal Rule of Civil Procedure 12b-6, it asserted that it had never participated or agreed to participate in an arbitration proceeding with Pena and that the award is a sham. It is noted that the petition follows Pena's other failed attempts to manufacture a claim against it in connection with the repossession of his car. The district court found that Pena was trying to enforce an award that was not genuine and was not based on a binding arbitration agreement between the parties. It noted that other federal courts had denied similar requests to confirm awards issued by Sitcom Arbitration Association because the awards were illegitimate. The district court stated that the purported award was incomprehensible, lacked factual findings and legal conclusions, and did not support the existence of an agreement between the parties. The district court further ruled that even if it disregarded the evidence of fraud, Pena had not submitted a valid agreement to arbitrate as required by the FAA. It thus granted TD Auto Finance's motion to dismiss and denied Pena's petition for confirmation. The district court denied his motion for reconsideration. And the court affirms the judgment of the district court. So this really got my brain going like, okay, well, what does this arbitration award look like? And what did he present to the court? The Federal Arbitration Act does allow parties to agree to arbitrate outside of court. And we've had some fun stories with this, like I think one of the food delivery companies, 4,000 employees or 4,000 independent contractors had brought arbitration claims against them. And arbitration is often more expensive than going to court, but sometimes it deters people from bringing actions if they have to go file paperwork with an arbitrator instead of filing things in court. It can be a hurdle. So the first thing that I did then was go back to the district court's determination to see what they had to say. This action arises from an alleged arbitration award issued by Sitcom Arbitration Association. Petitioner claims that the parties submitted to an electronic arbitration proceeding in June of 2019. According to petitioner, Sitcom issued the arbitration award of $116,000 in petitioner's favor. Petitioner filed the application on December 20th, 2019, arguing that respondent is barred from contesting the award. Under the FAA, a party may apply for an order confirming the award within 1 year. Even under this standard, though, the court may vacate an award under narrow circumstances where it finds the award was procured by corruption, fraud, or undue means, the arbitrators demonstrated partiality or corruption, the arbitrators were guilty of misconduct, or the arbitrators exceeded their powers. Among other things, respondent argues that the court should dismiss the application because the arbitration award is a sham. After reviewing the arbitration award and other case law analyzing similar awards from Sitcom, it is clear that petitioner is attempting to enforce a non-existent arbitration award that is not based on a binding arbitration agreement between the parties. skepticism about Sitcomm's validity as an arbitration entity and finding its awards to be illegitimate. And so they refer to a bunch of other cases here. Sitcomm's apparent illegitimacy is presently the subject of a lawsuit pending before the Southern District of Mississippi, where the plaintiff, Pennymac Loan Services, has argued civil conspiracy and violation of the federal RICO statute. You know how it's never RICO? Guess what? This one was RICO. Against this backdrop, the court finds that dismissal of this action is warranted. The arbitration award here appears to be no different than those rejected by other courts that have brought Sitcomm's apparent predatory practices to light. Like those awards, the arbitration award is largely incomprehensible, uses repetitive, nonsensical legalese, fails to support the existence of any agreement between the parties, and is devoid of specific fact-finding and legal situations. Gee, who does that remind you of? A certain kind of citizen who, what is it? The state is sovereign, and if you're a citizen and you're also not subject to the power of the state, yeah, we're getting there. To make matters worse, the arbitration award is identical to arbitration documents relied on by petitioners in other cases, except specifics such as names, dates, and monetary amounts. Sitcomm's careless copy and paste style of decision-making further casts doubt on the award's legitimacy. Second, even if the court disregarded the overwhelming indicia that Sitcomm's arbitration awards are procured by fraud, dismissal is still appropriate because petitioner has failed to provide a valid agreement to arbitrate. To obtain confirmation of an award, the Arbitration Act requires the moving party to file 1. The agreement, 2. The award, and 3. Each notice, affidavit, or other paper used to confirm, modify, or correct the award. Here, petitioner submits a document entitled Show of Cause Proof of Claim Demand, which is not what any of those documents should be called, claiming it is the parties' arbitration agreement. This document is incoherent and fails to describe the subject of the dispute allegedly giving rise to the award. The court likewise cannot discern from Exhibit A any concrete terms related to arbitration. In addition, neither Exhibit A, which is not signed by the respondent, nor any other document submitted by petitioner, evinces respondent's assent to be bound by the agreement to arbitrate. In other words, they didn't agree. Accordingly, the court finds Exhibit A is not valid and grants the dismissal application. So my next question was, oh God, I want to see one of these agreements. What did the person file? Show of cause, proof of claim demand, served or presented via the United States Postal Service by the United States Post Office via first-class postage prepaid. Lawyers do not do that. So that's, if I was a judge, that'd be the first thing I'd look at is, wait a second, what lawyer would ever call it that? And then there's all the parties, and then it says, to the holder in due course and agent and representative, I enter your name here, and associates have received your offer and accept your offer under the following terms and conditions. So they, the plaintiff, Marlon Pena, makes it sound like TD had made an offer of arbitration when that's not what's happened according to TD and according to the court. And so they require proof of claim, and then they have all these proof of claims that the Legislative Reference Bureau, reorganized by Act as a legislative agency, it's all this complex legalese, is not operating, functioning as an unconstitutional legislative entity. Proof of claim that the alleged statute laws of this unconstitutional entity. Gee, what is this starting to sound like here? And so they ask for all these proof of claims, and they basically say, if you don't respond to this proof of claim, then you are agreeing to arbitrate, is the short version of this. I, Franklin D. Roosevelt, President, do hereby proclaim that there shall be maintained banking institutions and a bank holiday. What does this have to do with anything about confirming the award? This is long, and so I'm going to skim through this real quick, and I'll provide links to this stuff on my Patreon. Here's a copy of Marlon Pena's attempt to get them to agree to respond, or else they'd be in default, which is really not how that works either. And so then here's the arbitration award. The parties have agreed that a judgment of the court shall be entered and an award made. and then it ends. So here I am doing my research, trying to find a copy of the final arbitration award, and I get one page, which is not an award. I'm not even sure if the actual arbitration award was sent to the judge. So I was out of luck and I needed to move on to a different case to try and find a arbitration award. So then I looked at Castro v. Bank of New York Mellon, which was mentioned in that case. And long story short, it's very similar. Petitioners are attempting to enforce a non-existent arbitration award. As respondent explains, many institutions have recently been experiencing an influx of a fake arbitration award, and then they give a lot more case citations that we can look up. So I started doing exactly that. I spent a few dollars downloading an arbitration award from Imperial v. Thomas, and this is what I got. And unfortunately, that's not really going to do it. But you can see here that it looks pretty much like the one that was given to Pena. This one's much longer. It's 22 pages long, but it's basically illegible. And I'm not going to subject you to trying to read through this. However, there was a decision in Imperial Industrial Supply v. Thomas, and it tracks with the Second Circuit's as well. This appeal concerns the validity of arbitration proceedings conducted by Sitcomm Arbitration and two of its employees in a dispute with Quintina Maria Thomas. She began sending Imperial a document titled Conditional Acceptance for Value for Proof of Claim Agreement, which purported to be a binding, self-executing, irrevocable contractual agreement evidencing Thomas's acceptance of Imperial's offer. The alleged agreement did not define what Imperial offered, but stated that a product sale, purchase agreement, and warranty for the generator created an ongoing contractual relationship between Imperial and Thomas. The alleged agreement further provided that Imperial would need to propound 15 different proofs of claim to Thomas in order to avoid 1. Breaching the agreement, 2. Admitting by tacit acquiescence that the generator caused the fire, I guess there was a fire, and participation in arbitration proceedings. Then Thomas sent Imperial 2 notices. The first notice purported that Imperial breached the alleged agreement by failing to provide the proofs. This notice allowed Imperial to cure the alleged breach by providing proofs of claim within 3 days. In addition, the notice stated that Imperial's refusal to follow the curing mechanism would result in Imperial's admission and confessed judgment to the alleged breach. The second notice stated that Imperial owed the balance of the entire contract value of $500,000. A few months later, Imperial received a notice of arbitration hearing from Sitcomm. The notice provided a date and time for a hearing, but did not provide a location for the hearing or a description of the matter under review. Imperial submitted several objections out of an abundance of caution. Without responding to Imperial's objections, Sitcomm then sent Imperial the final arbitration award on June 24, 2019, awarding Thomas $1.5 million for breach. The final arbitration award indicated the basis of arbitration was Imperial's consent by tacit acquiescence. That's not usually how that works. There is something in contract law or just in general in the rules of evidence. If you can't get somebody to agree to something, let's say you make a verbal agreement for something. You meet with your landlord and they say, we will agree that the damage to your apartment is $500. And you say, okay, I'll pay $500. And then later on, it turns out the landlord wants $2,000. Well, how do you refer back to that verbal agreement? You probably don't have any proof of it. Well, what could you have done? One of the ways that lawyers tell their clients to try and help with that situation is that you write, a letter. You say, this letter is just to confirm our verbal agreement that I'll pay $500 for the damages, and this will settle the matter between us. Then if the other party doesn't write back with a correction saying, no, we said $2,000, you can then bring that into court when you have your later dispute and you can say, look, I confirmed that it was $500. I made a writing contemporaneously with the verbal agreement that said, here's what we agreed to. And they didn't say, no, we didn't. They didn't deny it. This is kind of like that. But that's not a contract. That's just evidence that there was some kind of agreement. And so I think that's what they're trying to do here, is say that because you didn't respond, and they're making it as complex as possible to make it hard to respond. So you didn't respond properly, therefore you agreed to arbitration. Meanwhile, we have this fake arbitration company that's going to give the plaintiff an automatic award. So the Fifth Circuit Court of Appeals, I think this is, in Imperial Industrial Supply v. Thomas, also says that there wasn't a valid contract. Tacit acquiescence between relative strangers ignores the basic tenets of contract law. If Thomas's argument was valid, it would turn the notion of mutual assent, a basic contract principle, on its head in ordinary purchase cases like this. Buy an item from a dealer, mail a letter saying you agree if you don't object, and you then have whatever deal you want if they don't respond. Thomas fails to cite a single case that would support such a ridiculous notion. Other than buying a power generator from Imperial, Thomas has offered no evidence of previous dealings. Certainly she offers no evidence that would support silence as acquiescence. So then the Fifth Circuit Court of Appeals affirms the district court's order granting Imperial's motion to vacate any arbitration award. So then I looked up another case, because we didn't get an award there, because that was the one with the fax machine award. And I found Nichols v. U.S. Bank. Plaintiffs filed a petition with this court seeking confirmation of a purported arbitration award in their favor and against defendants in the amount of $1.8 million. As the court noted in a separate case, several cases involving sitcom arbitration have been filed with this court. Like their filings in previous cases, plaintiffs' pleadings here consist of a bizarre jumble of inconsistent, nonsensical word salad. The bottom line is that plaintiffs claim they have received a favorable arbitration judgment and they want this court to enter a judgment confirming it, presumably as a prelude to execution. U.S. Bank argues that there is no arbitration agreement, and plaintiffs contend that defendant waived its right to challenge the award. And then the court goes through what you're now familiar with is a similar evaluation. There was no agreement to arbitrate, the award is a sham. In the process, though, we got Nichols' affidavit. I, Boris Nichols, being of sound mind, am a party to an arbitration agreement. Now comes the aggrieved woman, Tawny Nichols, an aggrieved man, Boris Nichols, as natural conscious persons, as ones of we the people. This is starting to sound like something familiar. The facts of the case have been ignored. These are all conclusions, like where's the arbitration award? The claimant has not been afforded due process. This thing is 19 pages long. The court is operating under maritime law by the fringes of the flag. It's a sovereign citizen. The claimant recognizes the court's agents perform, prosecute, and bid on cases lacking true and valid evidence. The agents of the courts are as pirates at sea, removing vast numbers of claimants to their rightful booty and destroying the claimants and the people's right to pursuit of happiness, life, liberty, and freedom. There's so much more, but guys, we have to get through this. When claimant requested motion, equity, never answered. It's the King James Bible is in here. Repetitive abuse and misuse of process. Where is the darn award? He actually appealed what we call removal from state court to federal court. That was denied. The whole thing was over a foreclosure action by U.S. Bank, and it seems that his attempts were attempts to delay the foreclosure and occupation by the bank of the premises. And then Nichols submits 511 pages of exhibits. But in here is the award. Here is what a final arbitration award looks like from Sitcom. And it looks remarkably similar to the ones we saw before. This time, the arbitrator's name is Mark Moffat, and it says gibberish. Arbitrator has subject matter jurisdiction, having entered into an agreement, failure to respond, etc., etc. The above matter was set for arbitration. The contract has some really strange file name, which I don't think that that's what U.S. Bank would have used. The parties entered into a contractual relationship. The arbitrator finds all the elements. Normally, an arbitrator's award would give the reasoning, would say, okay, here's the background. So everybody's got the background facts, and then here's how I'm ruling, and then here's why. Issue, rule, analysis, conclusion is the typical way that lawyers write these things. So instead, it just refers to a contract that doesn't exist and then gives pages and pages of gibberish. The amount in controversy exceeds $75,000. What does that have to do with anything? That's the diversity jurisdiction in federal court number. Why does that have anything to do with an arbitration award? So it's starting to sound to me more like sovereign citizen stuff. The basis for arbitration, again, was referring to a contract. Why do we have to keep repeating that if it's a decision by an arbitrator? So a judge reading this would their ears would perk up, and why do you keep repeating yourself? Why is this written in the wrong font? Why is this written in the wrong spacing? Double spaced 12-point font should be approximately 23, 24 lines per page. There's clearly more than that numbers of lines. It's made to be word salad. It's made to be difficult to read because maybe somebody will just give up reading it and just pay the award. And so this just continues and continues and continues here. I'm not even sure if we've gotten to the amount of the award. I'm not even sure how someone can write all of this without knowing what they're writing. Emergency economic banking relief. What is all of this? This thing is so unnecessarily long. If it was a default, you would just write, you know, here's the basic facts of the case. We sent notice via all these different means. They didn't respond. We finally decided to hold the arbitration hearing anyway, and the plaintiff made their basic case, and so here we have a default. They cite something to Justice Kavanaugh. The conclusion follows not only from the text of the act, but also from the press. What does any of that have anything to do? It is word salad. It is gibberish. Here we go, finally, 64 paragraphs and 19 pages into a supposed default judgment, we get a $200,000 reward, times 4 to $800,000. And yeah, he also provided the certificate that Mark Moffett is a valid arbitrator. He provided some kind of summary of the arbitrator's award, which also seems like it's pretty long, and then gives the same $800,000 reward. Meanwhile, the sheriff finally ousted them from their home. So yeah, that was great, but then, I saw something else pop up in the U.S. Bank case. This is a real decision by the Southern District of Mississippi. On October 28, 2019, plaintiffs filed a petition with this court seeking confirmation of a $1.8 million award. Okay, it was 1.8, not 800,000. As the court noted, several cases involving Sitcom have been filed with this court. Like their filings in previous cases, plaintiffs' pleadings are bizarre jumble of inconsistent, nonsensical word salad. In short, plaintiffs claim that they received a favorable judgment and they want this court to enter a judgment confirming it. In response, U.S. Bank argued there was no arbitration agreement. The court found that plaintiffs had not presented evidence to contradict the declaration from the bank's officer, which stated that defendant had not entered into any arbitration agreement. The court found the arbitrator had no authority to enter an arbitration award, and the court denied the plaintiff's motion for confirmation of the award. In the court's previous order, it ordered plaintiffs to show cause why they should not be sanctioned for seeking confirmation of a purported arbitration award when there was no valid underlying arbitration agreement. They provided no meaningful response to the court's order, asserting the same arguments they presented in their motion to vacate, which the court has denied. The court has inherent power to sanction. Therefore, the court finds that plaintiffs knowingly or recklessly raised an objectively frivolous argument by seeking confirmation of a purported arbitration award when there was no underlying arbitration agreement. For these reasons, the court believes sanctions are appropriate. The court awards defendants its fees and costs in plaintiff's frivolous attempt to gain this court's confirmation. This encompasses all fees and costs incurred since plaintiffs filed their motion to confirm that would not have been incurred absent plaintiffs' bad faith behavior, and then that is March of 2020. What did they win? I pulled that document for you as well. The defendant requested $17,100 in fees, and the court awards $17,100 in fees. So that means that Boris Nichols and Tawny Smith Nichols are now jointly and severally liable for another $17,100. So whatever they paid to Sitcom Arbitration Association, they now owe the bank another $17,000, and both of them are liable for it. It will probably be on their credit report, their credit history, and the county will have records, likely the county will have records of the execution of the judgment against them. In another case, McGee v. Nation Star Mortgage, the judge actually referred this Sitcom Arbitration Association and the parties who used them to the Attorney General. For the reasons set forth below, the court denies the motion to enter the arbitration award, vacates the award, refers this order to the United States Attorney's Office for the Northern District of Texas, and the Attorney General's offices for Michigan, Mississippi, Hawaii, Virginia, Georgia, Wyoming, and Nevada. And then this case goes into the same kind of exploration, but there is still so much more to see. On December 11th, 2019, Pennymac Loan Services decides to hit back and sues Sitcom Arbitration Association, Mark Moffat, Sandra Goulet, Ronnie Kahapia, Mark Johnson, Kirk Gibbs, and Alaric Scott for a declaratory judgment, injunctive relief, libel, tortious interference with a contract, violation of RICO for conspiracy, and to vacate the arbitration award. And this is epic, and I'm going to try and do it justice for you. I pulled a lot of these documents from the Pennymac case, but the Pennymac case is huge. This thing went through a lot. The defendants tried to object, but they didn't object properly. Many of them were held in default, but then they undid the default by saying that they didn't understand or they still wanted to. But then the court undid the default by saying that pro se parties should be given a chance to attack the plaintiff's case on the merits. This thing is really complex, and so I've tried to pull some of these documents for you, which we're going to look at here. So then in this case, there's another final arbitration award. This one looks a little more like a court order. There's seemingly better font and spacing, but it's still the same text. Uniformly settled, claimants' rights, and all that. This one's only 10 pages long, and then it goes into a $2.25 million judgment against Pennymac, which of course is a sham. So Pennymac files a RICO notice that this is actually a RICO case. Kahapia counterclaims, an affidavit discovery, dismiss upon failure to state a claim. But you know what he didn't file was an answer, so that would make him in default. Mark Johnson submitted a handwritten answer. He says, a British foreign agent has elected to use my name in a fraudulent manner, hired by Pennymac to harm me. Pennymac is a debt collector and bank operating out of and headquartered in Los Angeles, California, a rogue and unconstitutional sanctuary city in direct defiance against the President of the United States. What? Has no understanding of concepts of federalism. California is a sovereign state of the United States of America, and California can govern itself within the limits set by the U.S. Constitution. So it is in no way an unconstitutional sanctuary city in direct defiance of the president. That's not how that works. It is my belief that the British foreign agent is pitting the court of Virginia against the court of Mississippi. What does this have to do with anything? And he's got a seal that says, tell Tubaya to the utmost. Wow. Okay, so this happens. Sitcom gets defaulted for not responding. The Sitcom Arbitration Association did not respond, so the plaintiff Pennymac applies for default. The court denies Cahapia's motion for dismissal. To some extent, it appears Mr. Cahapia argues that plaintiff has failed to state a claim. However, the court finds that plaintiff has stated a claim. A review of the complaint reveals that plaintiff has sued Mr. Cahapia for his own participation in the allegedly fraudulent arbitration scheme at issue. Finally, to the extent Mr. Cahapia argues that there is no subject matter jurisdiction, he's incorrect. The plaintiff has alleged it is completely diverse. The jurisdictional limit has been met. Therefore, the court finds it's appropriate, so his affidavit demand to dismiss is denied. Then Sandra Goulet opposes default. She claims that she sent an answer to the opposing party or maybe to the court, but the court didn't put it on the docket, so I don't think that she did send it. But she claims that she did, so even though she claims that she answered, she files a motion to dismiss, which you wouldn't file a motion to dismiss really unless maybe you had a jurisdictional complaint. There's a couple reasons you could file a motion to dismiss after an answer, but usually you file it before the answer. So she's attacking jurisdiction, which, as you just saw, the court says that they have jurisdiction. She makes the following arguments. The plaintiff, with the aid of counsel after receiving the contract, stated that plaintiff is in fault of the agreement and has consented. I don't think Pennymac stated that they were in fault and consented. You'd have to provide the proof of that. It is the plaintiffs who admitted that the defendant sent legal notification per the arbitration clause. So she's doubling down and she's arguing that the arbitration clause applies. She says that plaintiffs have received a copy of the contract. There was a prior relationship. They are all adults. They received notice of the change in terms. They were given an opportunity to reject. They were notified of a hearing. They were given an opportunity to appear. They received a copy of the award. They were knowledgeable of the 90-day statute of limitations. Is there a 90-day statute of limitations? But you also can't get someone's assent to a contract by sending them a notice. You must respond, and if you don't respond, you somehow have a contract. That's not how this works. So she makes 10 pages of ridiculous arguments. The court then makes another order. All of these documents. Now we have something by a party named Eeon. And I went to Mr. Eeon's YouTube page, and he's talking about arbitration and things there. So I think Eeon might be connected to Sitcom in some way. Then we have Mark Moffat's motion to stay the proceedings. He was one of Sitcom's arbitrators. He asks the court to set aside the default, but then apparently doesn't show good cause. Eeon is Brett Jones. A search for Brett Jones reveals this guy. Eviction protest led cops to Salinas sovereign citizen, offender with long alias. Brett Jones, 51, was found guilty of 2 counts of failing to register as an offender while living in Salinas and Carmel, Deputy District Attorney Lana Nasura said for the Monterey County DA's office. That's his picture. He represented himself, even though he refused to speak, but he posted videos to YouTube. He was mum at trial. He had plenty to say at his preliminary hearing, which was expected to last an hour but ended up spanning 2 days. Jones wore a gray hooded jacket and black shirt and described himself as a sovereign citizen who has 30 years of court trial experience, but said he can't normally work because of medical issues. They go into describing sovereign citizens. He filed many meaningless documents in his case, and he posted apparently a video to YouTube about it that I just can't go into right now because there's still so much more in the Pennymac case. He makes a motion to intervene in the case. Goulet opposes the motion to strike some of her meaningless things. The court denies Eeon Brett Jones' motion to intervene. Someone named me files something on the docket. What happened to Judge Keith Starrett? Is Michael T. Parker Jewish? I do not say I believe, I say I know. Pennymac is a fraud, and all institutions on American soil which are banking in the manner which Pennymac chooses to do is fraud, etc., etc., etc. I will post a link to all of these documents on my Patreon, patreon.com/ljfrench. The court issues an order against various motions. The arbitration award was in favor of Ronnie Kahapia and Mark Johnson. Plaintiff alleges these awards are part of a fraudulent scheme and brings an action. And I'm not going to go into all of the different rulings, but the judge basically denies all of their different rulings. Motion to strike, motion to this, motion to that. Plaintiff's motion to dismiss the counterclaim, and the judge then rules that all of the defendants' motions are denied and the motion to dismiss the counterclaim is granted. Any counterclaim attempted is hereby dismissed. The court then also denies some kind of motion by Brett Eeon Jones and denies his motion to intervene. He is not authorized to file documents on behalf of Sitcom. Why? Because Sitcom is an LLC and the proprietor/owner of the LLC cannot represent the LLC. Those are two separate entities. The LLC has a conflict of interest when there is a lawsuit against the LLC with the owner. So he can't represent both. Brett Jones is not licensed to practice law. He's not authorized as Sitcom's founder to file documents, but he seems desperate to be involved in the case. Mark Johnson writes another handwritten letter. I dare to learn correct sentence structure and correct parse syntax me. I await to address the Court of Appeals. Why would he need to address the Court of Appeals? He hasn't adjudicated his case in the district court yet. In the plantation era, Mississippi allowed the worst carnage to unfold on hapless black men. Okay, great. I agree that bad things have happened to people of color. Okay, and to this day, Pennymac goes whistling as he takes his chattel to the whipping post. Is this a legal argument? I am a signer of the Declaration of Independence. No, I don't think you are. I am an American national. I am a statesman in private in the Virginia Union, state and republic. I am, above all things, I am that which God has made me. Great lengths now been taken by a group that I know to be adversary of all men, bankers. Okay, so he doesn't like bankers. Okay, great. So then Pennymac grants Eeon's wish and files a amended complaint against Brett Jones, aka Eeon, aka Brett Toriano Jones, Theophilus, aka Brett Randolph Toriano Keefe, Henry Kana Shapel, Hithrapes Jones. Wow. And it's the same thing. It is a complaint that says the final arbitration award consists of various forms that fail to reference any specific details, instructs paying customers to attempt to enforce Sitcom's arbitration awards. Plaintiffs believes that the scheme is promulgated by Brett Eeon Jones. He is the ringleader, says Pennymac. So now, wait, we have an amended complaint that resets everything. Everybody now gets a new date to file a motion to dismiss, gets a new date to file their answer, etc. So Pennymac files a bunch of stuff. The Profit Corporation report for something called Innovated Holdings, which is apparently the parent company of Sitcom. It files the proof of service for Ronnie Kahapia's notice of arbitration hearing. It files the all-purpose proof of service for Ronnie Kahapia's arbitration award. This is what they received. It's saying that we received these things from these defendants. And then it files the one for Mr. Jones, for Mark Christopher Johnson. This is the notice of the arbitration hearing. This is the Johnson arbitration award. Similar, look at the structure. It's the same structure. It is now limited to 10 pages or 9 pages. And I'm not even sure where the darned award, where is the award? Oh, I guess here it is, $2.25 million. And then the clerk's entry of default against Innovated Holdings and Sitcom for not responding. Also, Brett Jones didn't respond, and also whoever Rance McGee is in default. So then, after being defaulted, Mr. Jones tries to file something called a challenge to the court's jurisdiction, etc. He's already been defaulted. He makes a motion to change venue, which appears to be handwritten, and I don't know where he was at the time, but if he didn't have access to a computer or a Kinko's to print it out, maybe he wrote this in prison, I don't know. Pennymac makes a motion for a default judgment. Plaza Home Mortgage tries to intervene. Oh, I have reached the maximum number of files that I can have open. I've got to close some of these. Save, close, 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 all of these. Save, close, 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 save, close, 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 save, close, 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 save. I've reached the maximum number of files. Eeon's motion to change venue is denied. Pennymac's motion to compel the deposition and for future sanctions where a party fails to appear for a noticed deposition. So Ronnie Kahapia apparently did not appear for their deposition, and so that is granted. The motion to compel is granted, and Ronnie Kahapia shall provide plaintiff 3 dates where he is available to sit for his deposition. Mark Johnson, similarly, must serve his initial disclosures. Initial disclosures are what evidence do you have? Mark Johnson also needs to provide dates for his deposition. Mark Moffat, the arbitrator for Sitcom, he hasn't served his initial disclosures, and he has to sit for a deposition as well. Kirk Gibbs, who I think also works for Sitcom, also has to sit for a deposition and provide his initial disclosures. Sandra Goulette, who also works for Sitcom, I believe, has to serve her initial disclosures. None of these people followed basic civil procedure. I can understand it. It's complex. That's why you hire an attorney. Plaza Home Mortgage's attempt to intervene is also denied. I think they were just looking for an easy win since Pennymac is doing all of the work here. Pennymac says that the sanctioned defendants have failed to pay for their missed depositions, approximately $1,000 to $1,200 each. Eeon tries to set aside the default judgment. He writes a memo in support, which is not written properly, but he tries to get out of a default, saying that there was no proper service on him, but of course there was. And then on August 2nd of 2021, just as I'm researching this case, the judge enters the default judgment. $1.384 million in favor of Pennymac Loan Services against Innovated Holdings, Sitcom Arbitration Association, Mark Moffat, Sandra Goulette, Kirk Gibbs, Brett Eeon Jones, Rance McGee, jointly and severally as to plaintiffs' claims in the amended complaint for libel/defamation, tortious interference with prospective economic advantage, civil conspiracy, violations of the Racketeer Influenced and Corrupt Organizations Act, and conspiracy to violate RICO in their 7th claim. And so jointly and severally means each party is liable for the $1.4 million until the $1.4 million is paid. So Pennymac can execute against their income, their property. It can go on the record in any county that they live and go on their credit report, etc. If Pennymac actually does visit or attach or execute that judgment against them. The court finds that plaintiffs' motions are well taken and should be granted, and the court breaks out the damages, including $210,000 in punitive damages, almost $600,000 in actual damages, $140,000 in treble damages for RICO, and $384,000 in attorney's fees, which I'm not sure that Pennymac will actually ever see. And that's the story of the Sitcom Arbitration Association. This is the Sitcom Arbitration Association website, or what it used to say, because the website is now down, and it shows that customers would pay a couple $100 for these fake documents, and then I'm assuming there was some kind of add-on. It seems to be a hastily constructed sort of template website with stock photos and just paragraphs sort of meant to give it an air of legitimacy. It has 4 copies of its terms and conditions, where it just sort of copies and pastes case law or statutory law about arbitration. And if I page through here, you'll see it's a very long document. And this website just goes on and on and on like this, I guess trying to convince people that this sort of thing is legitimate. Some of these links seem to just go to like a directory. Some of these links are not found. And if you go to sitcom.com today, it's sitcomm.com, you can see that there is nothing. It's just a blank page. So I'm assuming that that was either taken down by Pennymac or taken down by Brett Jones, who doesn't want to suffer another $1.4 million jointly and severally liable damage award. So that was a lot, and that was a huge adventure for both you and for me in finding all of that. I will put an archive of the 75 or so documents that I have up on patreon.com/ljfrench, and you can go there if you would like to get a copy and peruse through. There's hundreds and hundreds and hundreds of pages to go through, but it looks like just as Dan helped me uncover a arbitration troll, the judge shut them down, at least through a major award. Let me know what you think of that story in the comments below. This one was RICO. And that's today's video. Special thanks to our top supporters in August: John Steele, Gavin Barnard, Evie, Spirit Bear, Benjamin Hightoff, Ugly Grill, Torpedon, Brandon Abel, Shadow Tycho, RDH Dragon, Earthbound Star, Pure Magma, Drew Hart, and Eric Tams. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye. I gotta pull the... So then in this... Whoops.